Good afternoon. For those that don't know me, my name's Matthew Oakey. I'm a partner here at SW Accountants and Advisors, and it's my pleasure to welcome you to an Agribusiness, estate planning and power of attorney webinar today. Firstly, I'd like to acknowledge the traditional custodians throughout Australia and their connection to land, sea and community. We pay our respects to their elders past, present and emerging. Today, we'll be discussing estate planning, and I'm pleased to be joined by Jessica Moyle, who's an associate at Dawes, Very, Reardon Lawyers. Some housekeeping before we start. We'd recommend that you click on the Enter Full Screen button at the top right-hand corner to achieve the best webinar experience. If you click the Q&A button at the bottom of your screen, a window will pop up, which will allow you to send us questions as we go. We'll monitor these questions and answer these questions as we can during the presentation, and we may save some of the Q&A for the end. Any bespoke or questions that we might consider need a private answer, we'll connect with you after the session. Before we kick off, we're running 2 live polls today. The first poll will appear on your screen now and can be accessed at any time using the poll button at the bottom of the screen. Once you answer the question, it'll disappear. So as you can see, our poll is, do you have a will and when was it last time updated? The answers are, or possible answers are, no will, yes in the last 12 months, yes in the last 5 years, yes in the last 10 years or more than 10 years. So we'll give those results to you later throughout the presentation. So we'll give you an overview of what we're covering in today's session. So we'll be covering wills and power of attorneys. The power of attorneys will be for financial, legal, personal and medical decisions. How to structure business enterprises to allow smooth succession for the next generation, which is very important in the agribusiness space. Water and farming assets and ownership structures. The taxation treatment of testamentary trusts. Capital gain consequences when assets pass to a beneficiary. And in particular, we're going to look at some small business CGT concessions and what happens to your superannuation. So I'd like now to introduce Jessica. Jessica, as I said, is an associate at Dawes and Very, Reardon Lawyers. Jessica was born and raised in Echuca, and after completing her work experience at Dawes and Very, as it was then known, in 2008 during high school, she knew that she wanted to work as a lawyer in a country town. After graduating with honours at Deakin University in Geelong, she moved back to Echuca and began working at Dawes and Very Reardon as a graduate trainee lawyer and completed her supervised workplace training in 2016 before being admitted to practice in 2017. Jessica works in a number of areas of the law and prides herself in staying up to date with new legislative changes and ensures the firm's client receive a thorough, prompt and professional service. Jessica is passionate about delivering legal information to the community in an accessible way. So I'd like to welcome Jessica and hand over to Jessica to start the presentation.
Excellent. Thanks so much for that, Matt, and thanks everybody for joining us today. It's really important to us at Dawes and Very Reardon that legal information is accessible to the community. And so the purpose of today's session is to take away some of the guesswork around wills and powers of attorney so that people don't feel like these documents need to be in that too hard basket that just get pushed to the bottom of your to-do list. So with that, we'll make a start on wills. So one of the main questions that we often face from our clients and the community is, why should I bother thinking about this now? I'm quite young. I still have my wits about me. My assets are straightforward enough. I don't have that many assets anyway, are some of the common reasons that we hear as to why people tend not to worry about these sorts of things. However, as one of the people who helps families through situations where their loved one didn't have a will or doesn't have a power of attorney in place, I promise you it's usually much easier to deal with these situations when they have the correct documentation in place. Families are often stressed enough during these times without the added burden of dealing with complications like not having the appropriate wills or powers of attorney in place. And although it's not fun to think about, putting these documents like a will and a power of attorney in place will mean that you get to take the pressure off your loved ones in the event that something happens to you. It's also a really good way to make sure that you're staying in control of your decisions, making sure that you've appointed people that you trust to be in charge of your circumstances. And it's a really great way to set things up now so that you don't have to worry about it later. So the main document that I wanted to run through today in terms of your wills is how we go about putting a will in place. So essentially, in order to make a will, you need to be able to tell me three things. Firstly, what your assets are. Secondly, who you want to leave them to. And thirdly, who you want to leave in charge of your estate to distribute them for you. So if you're not sure where to start, that's fine. But a bit of a common saying for us is don't let perfect be the enemy of the good. So if you're not sure where to start, more than happy for you to touch base with us and arrange an appointment, and we can get those conversations working for you. It's much better to have some documentation in place, even if it doesn't answer every question perfectly, than to stick your head in the sand because it all feels too hard. And it's our job to assist our clients, offer strategies, suggest solutions, and try to work with them to find a situation that will work ideally for their circumstances. And we do this every day. So chances are one of our other clients might have struggled with a similar issue to you, and we might have worked through that with them before. So we might have a bit of a conversation around your executors. So for those of you who are not sure what I mean when I talk about an executor, your executor has the role of stepping into your shoes if you've passed away and dealing with your affairs and ensuring that everything is distributed as per the terms of your will. So you can have more than one executor, but please do all of the solicitors and accountants involved in your estate a favour and make sure that your executors get along if you are appointing more than one, because it can be a really stressful job at the best of times, and it's really important to make sure that your executors are going to work well together. And secondly, make sure that your executors know that that's their job. They know that they're your executor. It can be a really daunting process for somebody to act as someone's executor. And it may be that they might like to ask you a few questions about what you'd like them to do in specific detail, which they can only do if you let them know that they're your executor and can give them that guidance as a starting point. So just something else to be mindful of when you're talking about who your executors are. Whenever Dawson Berry read and draft wills for their clients and we have them all signed and we send you out copies for your records, we also like to send you a blank executors dossier, which we basically treat like a cheat sheet for your executors. So that's a document that you can fill out with all of your details about your assets and guidance that your will might not include that you might want to give to your executors about how to administer your estate. So the logic there is that we would like your executors to have as much information from you directly as they can, so that the job of acting as an executor is not quite so daunting for them. So now that we've covered off on executors, we'll have a bit of a conversation around assets. So we'll talk a little bit about ownership of assets later, but it's important from our perspective at Dawson Berry Reardon that we take really detailed instructions about what land, what investments, what shares, and what other assets you might have, so that your wills can be drafted appropriately and in a tax-effective manner. Now, it's really important when we're talking about which assets we deal with in your will that we only deal with estate assets and not non-estate assets. So what I mean by non-estate assets are assets that you don't own personally. So it may be an asset that's held in a self-managed super fund or in a family trust or a company. It's really important that we understand the right ownership structure of all of your assets so that we can advise you accordingly and make sure that your will is set up in such a way that it will function no matter what your circumstances are. Once we've established what your assets are, we then need to work on how you'd like to gift them in your will. Now, there may be specific family heirlooms or items of significant family importance that you'd like to pass on to the next generation, or you might like to include a charity in your will. Those are all valid options, and we're going to discuss some strategies for avoiding conflict between beneficiaries in our next session on the 15th of November. So that's really a bit of an overview as to how we go about structuring your wills with you. As I said, as long as you can tell me what you've got, who you'd like to leave in charge, and who you'd like to leave everything to, we can usually work through the rest with you. So we might move on to enduring powers of attorney. Now, in Victoria, the legislation that governs powers of attorney is aptly named the Powers of Attorney Act of 2014. So when I talk about a power of attorney, what we're talking about here is who can make decisions for you if you are alive but you don't have the ability to handle your own affairs, or you've chosen not to handle your own affairs anymore. So we're talking about decisions that impact your financial matters and your personal matters. So when I'm talking about financial decisions, what I mean by that is who can sign checks, pay bills, deal with real estate, and sign other legal contracts and agreements for you. Or as I like to put it with my clients quite frankly, who can empty your bank accounts and head off to Europe and have a great time on your dime if you don't make sure that you've got the right person in charge as your power of attorney. Now, the other sort of decisions that we can cover off on in this power of attorney are your personal matters. And what I mean by your personal matters are lifestyle decisions about where you live, where you work, your daily diet and dress, and those sorts of matters. So again, speaking quite bluntly, the personal power of attorney is the one who decides where you live. So if you have really strong preferences about whether you'd like to be in aged care or not, it's up to your personal power of attorney to make sure that they're respecting those wishes for you and making decisions that are in accordance with what you would want them to do. So a power of attorney can commence in sort of two situations. The first is that it can commence immediately once all of the documents have been signed. And secondly, a power of attorney can also commence when somebody loses decision-making capacity. Now, it's up to you as to when you would like your power of attorney to commence officially, but the general practice is that most of our clients tend to choose that those powers of attorney will commence immediately once they've been signed. And the reason we say that is that you might have a power of attorney in place, you might still have your capacity and be able to make your own decisions, but you might be overseas on a holiday, or you might be sitting at home with a broken leg and not be able to physically go into town and do your banking and deal with your affairs from that perspective. And that's where these power of attorney documents can be really useful, because you can instruct your attorney to make decisions on your behalf, or your attorney can also choose to step in if they're of the opinion that you're not making decisions that are in your best interest. So the alternative with that commencement is that the powers of attorney would only come into effect if you've lost decision-making capacity, and that might be a really difficult line to draw in the sand. So the purpose of these documents is to make sure that they're as functional and appropriate and useful as they can be. And that's why we have these really detailed conversations with you when you come in to see us about how you'd like to structure these documents so that they'll work really well for your circumstances. So when we're talking about appointing people as a power of attorney, I do use that word deliberately. It is a power of attorney for a reason. You're giving a lot of power and discretion to the people that you're leaving in charge of your affairs. One other good way to think of it is your financial power of attorney is essentially somebody that you should trust to have a blank checkbook. If you didn't trust them with that sort of decision-making capacity and power over you, then they're not the right person to have in this job. You can appoint multiple people if you'd like to have a bit of a check and balance in place as to who can make your decisions. So most people tend to appoint more than one person as their power of attorney. They might have one person in the first instance and someone else as a backup, or they might have 1, 2, or 3 people appointed jointly and severally. Now, what I mean by that is jointly means where every power of attorney has to sign the same check, pay the same bill, make every decision jointly. And severally means that the powers of attorney that you appoint can make decisions independently of each other. So for instance, if you have 2 children, one of them lives nearby and one of them lives interstate, it might be appropriate to appoint them jointly and severally. That way, your locally based child wouldn't need to correspond directly with your out-of-state child to get every document and every decision signed off on each time. Another option for how you might like to structure your power of attorney is by majority. So what we mean by majority is 2 out of 3. So for instance, my parents, and I have checked with them, I'm not breaching confidentiality by telling you this, they have 3 children, and obviously one of their children is a lawyer. So they've decided that I perhaps know a little bit too much about how to rip them off and get away with it. So as I am one of their powers of attorney, they've decided that they've appointed myself and my 2 siblings by majority. So if we wanted to rip mum or dad off, 2 out of 3 of us would have to co-conspire to make that happen. And the reason I use that example is because it's a good opportunity to figure out a way that you can structure these documents so that they'll work perfectly for your circumstances. Excuse me, sorry about that. So we might move on to appointments of medical treatment decision maker. Now, these documents used to previously be called a medical power of attorney, but when the legislation changed in 2016, these documents got a bit of a rebrand and they're now called an appointment of medical treatment decision maker. Now, it's important to note that if you did have a medical power of attorney before 2016, it is still perfectly legally valid. So you can appoint up to 4 decision makers in terms of who's in charge of your medical decisions for you, but they have to be in order of preference. So you have to nominate who you would want the doctor to speak to first, second, third, or fourth to make your medical decisions. And the reason these documents are structured a little bit differently to the enduring powers of attorney is that the medical profession got together and said to us solicitors, listen, please don't make me have to ask two different sets of children for two sets of instructions as to what should happen with their parents' medical care, because if I get two different sets of instructions, it's going to be really unclear. So that's why these documents are structured, so that you have to nominate in order of preference who you would want to be making your medical decisions for you. So one of the main changes to the new legislation that came into effect is that it's now up to your decision makers not to do whatever they think is best, but to make whatever decision you would want them to make for yourself. Now, it's a little bit of a subtle distinction, but that's why it's really important to make sure that you have a conversation with your decision makers about what your medical decisions would be in certain circumstances, so that they can be armed with the knowledge about what you would like them to do for you. And it can take a lot of pressure off the people who are in charge of making your medical decisions, because it's a really stressful position for them to be in. So sometimes it's really helpful for them to be able to go, well, I'm just doing what mum or dad asked me to do. We had this conversation and I knew what they wanted me to do in this sort of situation. So you can take things a step further with your medical decisions and put in place a legally binding advanced care directive, but those documents have to be prepared in consultation with your doctor. So an advanced care directive comes in two forms. There's an instructional directive and a values directive. And that instructional directive is where you specifically consent or don't consent to certain types of medical treatment. So if you have a valid instructional advanced care directive in place, your doctor can look to that document first before speaking to your medical treatment decision maker about what decisions should be made about your medical care. You can also put in place a values directive, and that values directive sets out factors that you would like your decision maker to consider when they're deciding how to make medical decisions on your behalf. So, for instance, your values directive might have statements such as, it's important to me that I'm able to recognise my friends and family. It's important to me that I'm able to live a fit and active lifestyle. So things like that. But as I said, it's really important that those advanced care directives are put in place with your medical professional assisting you with those documents, because they can give you the specific advice about your medical care that is appropriate for your circumstances so that you can make an informed decision. Now, we might move on from decision maker documents there and talk about how to structure your business enterprises to allow for a smooth succession for the next generation. So we've spoken about wills and powers of attorney, but something else to keep in mind when thinking about these assets that your will can deal with is how those assets are specifically owned. Now, most of our clients who operate their own business will use one of these four structures that you can see on the screen here. So it's important to be mindful of how each ownership structure should be dealt with in your will, which is why we work really closely with your accountant to make sure that we understand how your business works, so that we can advise you on the best way to transition the business to that next generation. So for instance, if you have a sole trader set up, the business assets would be in your individual name. So they can be gifted in your will to whomever you see fit, and that should be relatively straightforward. If you have a partnership assets are treated slightly differently and will be governed by your partnership agreement. Or if you don't have a partnership agreement, then the Partnership Act of 1958 in Victoria will determine how those assets are dealt with. So again, that's why we take really detailed instructions from you in our first appointment to make sure that we've got a really clear picture of what your assets are and how they're owned, particularly if you've got a company involved. So if your business assets are held in a company, then they actually belong to that company, not to you directly to dispose of in your will. Most often though, if you're the sole director or the shareholder of your company because you're the person operating that business, you should be able to gift those shares that you own in that company to the person that you would want to have take over the business so that they can appoint a new director of that company and take it from there. Now, assets held in a trust are different altogether. That trust itself is the entity that owns those assets. So the will needs to pass control of those trust assets instead of passing the assets themselves on. Now, it may seem like a bit of a subtle distinction, but that's why, as I said, it's really important that we take those really detailed instructions from you so that we can make sure we understand how your assets are owned, so that we can make sure that your will is drafted appropriately. Now, usually we'll be dealing with your accountant to get a copy of that trust deed so that we can specifically make sure that the wording of your trust deed reflects the wording of your will and that all of your key documents work in well together. So it might seem really daunting to think about handing over the reins of your business to the next generation, particularly when it's an enterprise that you've spent so long working on and so much time and energy and blood, sweat and tears building up. But that's why it's really important to us at Dawes & Berry Reardon that we encourage our clients to put just a fraction of that hard work into thinking about what their business succession plan might look like, so that they know that they have a smooth transition set up for their assets, and so that they don't have to worry about things falling into the wrong hands or there being arguments or disputes. So now that we've covered off on those business ownership options, we might have a bit of a conversation around water and farming assets and ownership structures there. So when we're dealing with assets that are owned in terms of real estate or water, there are a couple of different ownership structures that apply. So that's why, again, we take those really detailed instructions from you in our first appointment. We make sure that we get searches of those water assets or those real estate assets so that we're covering off on knowing exactly how those assets are owned. So for instance, if you own a property or some water as a sole proprietor, then that's relatively straightforward. It's purely up to you and the contents of your will to determine who that would pass to. But if more than one person owns water or land, then there are two ways that that ownership can be recorded. The first is as tenants in common. So tenants in common means that your share in that property is yours to distribute as per the terms of your will. So for instance, when two people own an asset as tenants in common, they essentially own half each, or they can own it in unequal shares. So it may be that one person owns 70% of the asset and the other person owns 30%. Now, that means that you have that discretion in your will as to who receives your share of that property or that water when it's owned as tenants in common. The other way to own assets and water is as joint tenants. Now, if you own an asset as joint tenants, it's treated kind of like a joint bank account, whereby if one person who is a joint owner passes away, it automatically passes to the surviving owner. And that can apply to water, it can apply to land, and it can apply to things like shares as well. So that's why it's really important that you're mindful that your will can't actually dispose of those assets that you own jointly, particularly if you're the first of the partnership to pass away, because that asset that's owned as joint tenants will automatically pass to your surviving owner. So that issue of ownership status comes up a lot, particularly in blended families. For instance, if we got instructions from our clients, John and Julie, who each had children from a previous relationship, and then John and Julie decided to buy a house together, they would probably buy that property as tenants in common. And the reason for that is that that gives John and Julie the ability to leave their half share in that house to their own children. So if John and Julie instead decided to own that property as joint tenants, and say John passed away first, that might mean that his children from his previous relationship could miss out, because that property would automatically pass to Julie, and she might not necessarily include John's previous children in her will. So that's why it's really important that we don't just ask you about what we want your will to say and who we want to include in it, but we take the time to get a really clear picture of what your assets are and how your assets are owned, so that we can give you the best possible advice on how to structure your wills and your powers of attorney. And with that, I might hand back to Matt to speak about testamentary trusts. Thanks, Matt.
Thanks, Jess. Just while I change the sharing of the screen, I might talk about our first poll and the results there. So the first poll we had, do you have a will? And when was the last time it was updated? 61% of people on the webinar have no will. And I've got to say, I'm not necessarily surprised by that. Estate planning is something a lot of people tend to, say, I'll do it, but they don't necessarily get around to it. 6% of people have updated their will in the last 12 months, 17% in the last 5 years, and a further 6% in the last 10 years, and 11% said yes, but it's more than 10 years old. Now, with a will, it is a dynamic document, and I would always recommend that you regularly review it and update it, because your circumstances change as you go along. Whether it's through a birth, a death, a marriage, changes to your business structure, you do need to update it regularly. So we might open the second poll now. And the second poll is in regards to, would your executor or family know where to find a copy of your valid will. It's important they should know where it is, because if you do pass away and it's hidden in a bank vault somewhere, you may not end up having a valid will if no one can find it. Okay, so we might move on to testamentary trusts. So some of the key advantages of a testamentary trust, and I should say a testamentary trust is a trust that is set up via a will. So it's not done as you would do with a normal family trust and go to a service provider and set up a trust with a deed. This is done through your will. Some of the reasons you do it is for asset protection, and it's to protect some of your beneficiaries from creditors. Family law matters. So if you wanted to keep the wealth within, with blood family members, you could use testamentary trusts. For financially irresponsible or inexperienced beneficiaries, so that they're those people that may have a gambling or a drug addiction, those that may have impaired mental capacity, or minors, so your children. And so the testamentary trusts are used to protect the funds that those people are receiving for their benefit. It also can be used to preserve capital for future generations. So you may provide income to a certain beneficiary during their life, who's called a life tenant. And then when that life tenant then passes away, the capital of the estate goes to the future generation, and they're called the remainderment. So for example, I've got a client who was a life tenant. She recently passed away. She was getting the income from listed, unlisted shares through this particular trust. Now that she's passed away, the capital of that trust will be split between her 3 children. In terms of taxation of testamentary trusts, there certainly are some advantages setting up a testamentary trust, particularly for minor children. The tax rates there, as you can see, the minor tax rates under Division 77A are quite punitive, particularly in that range of $417 to $1,307 at 66%. But then anything over that is taxed at 45% for a minor. And next to it, just as a comparison, we've got the normal resident tax rates. But if a minor is receiving income from a testamentary trust, they are eligible for the normal resident tax rates. So obviously paying tax as a normal person would be. There is certain requirements that the assets that are generating the income do come from a will. If they don't, then you may have tainted that income, and some of it may be taxed at the Division 6AA as opposed to the resident tax rates. So it's important to try, if you do have a testamentary trust, not to inject other income in there or other assets that come from outside the estate. So I might give you an example of how this works in terms of the tax benefit. So John and Jenny Jones have 2 children, Jack and Jill. I'm being very inventive with names there, both under the age of 18. So John passes away, leaving $1 million, yielding 3%. So that's $30,000 of interest per annum. John's will includes a provision for a testamentary trust for Jenny and the 2 minor children. Jenny earns $200,000 from her employment income, so she's already on the top marginal tax bracket. Jack and Jill have an absolute and indefeasible vested interest in the trust. And so if we look at the tax calculation there, so if it all went to Jenny, so there was no testamentary trust, the $30,000 would be taxed at 45% plus the Medicare levy, giving a tax of $14,100. So Jenny's retaining about $16,000. If it went through a testamentary trust to a minor, or minors in this case, 2, we could distribute them each $15,000. Because it is through a testamentary trust and the assets are from an estate, they're taxed at the normal resident tax rates. Therefore, there's no tax on that because the tax-free threshold goes up to $18,200. So as you can see, the family retains an additional $16,000 by having that testamentary trust in place. So the other tax advantages of testamentary trusts are that over other trusts is that any capital gain or loss that arises by an asset that's owned by a deceased person that passes into that testamentary trust, the CGT event is disregarded. So if you had a normal family trust and you wanted to transfer an asset into that family trust from your name, you potentially generate a CGT event in your own name and got to pay tax on it before you can get in the trust. Whereas if it goes via a testamentary trust, then that CGT event is generally disregarded. The above is obviously subject to CGT event K3, and K3 is where assets pass to a tax advantage entity. So a tax advantage entity is a tax exempt entity, so that could be a not-for-profit, a complying superannuation fund, or a non-resident. So we recently had an estate where the beneficiaries were non-residents, so we had to look at the K3 event. So K3, effectively, if the asset is passed to a tax advantage event entity, you've got to go back to the date of death, and in that return potentially include CGT on the gains made on those post-CGT assets. Just bear with me for a sec. I'll just. Okay. So we might move to the next slide. There is one exemption to this when it's passing to a not-for-profit, is that if the not-for-profit is also a deductible gift recipient, then the CGT event can be disregarded if the deceased person had decided to make that gift when they were alive and they would have got a tax deduction for it. And GS did mention about not-for-profits and charities, and one of my passions is charities and not-for-profits, and I do a lot of work in that space, and I'm also on the firm's CSR committee. So leaving a legacy set up through a private ancillary fund or a charitable fund during either your lifetime or your will, I think is a good idea. It's a great way to get your family involved in structured giving, and it also gives you an opportunity to claim a tax deduction in the year of a sale of an asset. So if you had a significant asset and you decided that part of those proceeds you wanted to put towards your philanthropic legacy, you can make a donation into a private ancillary fund to offset part of that tax. It should be noted that once those gifts are made into a private ancillary fund, they can't be revoked, so they're in there. If you do want any further information on not-for-profits or private ancillary funds, I'm happy for you to reach out and have a conversation with me. The next thing I'd like to talk about, given we're talking about agribusiness, is small business CGT concessions. Now, obviously, a lot of agribusinesses are small businesses, and small business CGT concessions are quite a complex area. We could probably do 3 webinars on it alone. So this is at a very high level. So I would recommend, if you do have any questions or queries or think that you may be eligible, that you reach out, because this will cover off on a very high level. But what it's there to say is that deceased estates can still access the CGT concessions, even though the person has passed away. So the legal personal representative, so your executor or the beneficiary of a deceased estate, can be eligible for the small business concessions, where the asset is disposed within 2 years of. Sorry, I should step back a little bit. I've skipped a slide. I might do a high-level overview of the small business concessions before I go into the deceased estate components. So. Small business entities with aggregated turnover of less than $2 million can access them. Now, when we talk about aggregated turnover, we're talking about not just the business's turnover, but those who are connected or affiliated with you. So you do need to check that there may be other income included in that turnover test. You also need to look at the net value of the CGT assets owned by you or certain entities, and they don't exceed $6 million just before the CGT event. The CGT asset must be an active asset. So generally they're assets that are used within a business. So it can't be, sorry, a listed share or a listed investment. And if it is a share in a company or an interest in a trust that's operating a business, there's certain other conditions that need to be met. There are 4 small business CGT concessions. The first one being the small business 15-year exemption. The second being the small business 50% active asset reduction. The third being the small business retirement exemption. And the final one being a small business rollover, so where you would roll into another asset. There are rules about the order of the concessions and how they apply, and how either current or prior year losses are applied with the CGT discount. Again, I would recommend that you get advice on this. It's a complex area, and there are a number of tests to get through before you can access those concessions. Now I'll go on to the next slide, which I started talking about before, which is the small business CGT concessions in relation to a deceased estate. So as I said, the legal personal representative or the beneficiary of a deceased estate will be eligible for the small business concessions where the asset is disposed of within 2 years of the date of death, and the asset would have qualified for the small business CGT concessions if the deceased person had disposed of the asset immediately before their death. If the above conditions are satisfied, the small CGT concessions are also available to the transferee, being the trustee of a trust if it was established by the will, or a beneficiary of that trust, or a surviving joint tenant. After the two-year time limit is up, if the transferee does not transfer the asset or use the asset in the business, the active asset test may not be satisfied. So that 2 years is a really important date. An extension of time can be applied by completing a private ruling to the commissioner. So you would do that, say, for instance, if there was a complex estate, it was difficult to get valuations for probate, and it may have taken 12 or 18 months to get probate. It's really hard to deal with the assets within that 2-year time frame. So you apply to the commissioner to get an extension of time on applying those small business concessions. In relation to the retirement exemption, which is one of those, there's a modified rule, and regardless of the person's age just before they passed away, there is no requirement to pay money into superannuation. The normal rules are that if you access the retirement exemption, if you're under the age of 55, you need to pay the proceeds into a complying superannuation fund. And if you're over the age of 55, you do not. So if someone passed away and they're under the age of 55, those funds do not need to go into a complying superannuation fund. I might now give an example of the 15-year rule. And this is from an ATO private ruling. So this is an actual factual case that the ATO have ruled on, and how the requirements were met, even though the particular event was not in connection with the retirement of an individual. So under the 15-year rule, exemption rule, there needs to be a retirement event normally, but where someone passes away, that connection isn't required. There's a modification. So in this case, the deceased carried on a primary production business on farmland, which had been owned by them for more than 15 years. The LPR, or the executor, sold the land within 2 years of the person passing away. The deceased taxpayer would have been eligible for the 15-year exemption had he sold the land just prior to his death. The CGT event was not required to have happened in connection because of the modified rule of obviously a deceased person can't retire. So that the executor could disregard the capital gain under the 15-year rule. So that asset was farmland was disposed of, and there was no capital gains tax paid on that by the estate. So as I said, this is a complex area. There's a lot involved in it. I guess we're just giving you a high level overview, and that to make you aware that these CGT concessions can still apply even if someone has passed away. Finally, I'd like to just move on to superannuation and just talk briefly about death benefits. Again, it's a complex area. You should seek advice from your accountant or financial planner. In many circumstances, it will need to be a financial planner because advice sometimes requires a financial license. When a member of a super fund dies, their entitlements need to be paid out in accordance with the SIST regulations. A member's benefit in a regulated fund must be cashed out as soon as practical. So there are potential liquidity issues there, particularly if you hold real property in, say, a self-managed super fund. You may have to sell those properties to pay out the death benefit. So that's where it's always good to look at your asset allocation and ensure that you've got a good mix of both liquid investments and non-liquid investments. The trustees generally have the discretion to pay out the funds, the death benefit funds, to who they think is appropriate. This is, of course, unless the member has made a binding death benefit nomination, and I'm going to talk a little bit more about that later, or it's a reversionary income stream. So a reversionary income stream, for example, is you might have a self-managed super fund with two members, a husband and wife. One of them passes away. Then the second one gets that reversionary income stream, so it continues on. And this, however, this is subject to some of the superannuation caps. So depending on how much money you've got in super, you still may have to pull out some money. In terms of who is a death benefit dependent for superannuation, it's the person's spouse or a former spouse, children, the deceased persons who are aged less than 18 years old, a person who the deceased had an independency relationship with just before they died, or someone who was dependent on the deceased just before they died. So for example, it may be an adult child where the deceased was paying for all their bills, their rent, those sorts of things, and they were financially dependent on them. So just to show you a slide, so you need to determine if there is an eligible beneficiary. If there is, then you may be able to pay a reversionary pension to them, or you may be able to pay a lump sum. If there's no eligible beneficiary, then your best option generally is to nominate your legal personal representative, so your estate, as the person or the entity to get your superannuation. I'd like to talk about a case, the Petrie case, which happened a couple of years ago. A young girl who had superannuation and she passed away. She was engaged to a gentleman, but she had nominated her mother as the beneficiary of her superannuation. Now, unfortunately, your parent is not an eligible beneficiary for superannuation, so that nomination was invalid. So the trustees decided that because she had a partner who she was engaged to, that person should receive the superannuation, and he did. Now that might not have been the outcome that this particular girl was looking for. So what she should have done was, in her binding death benefit nomination, was nominate her estate, and then through her will send those funds or will those funds to her mother, and that would have achieved the outcome that she wanted to. So it's really important that you get advice on who you're nominating for on your binding death benefit nominations, because I see in many instances people nominating beneficiaries that aren't actually eligible beneficiaries. If you do have any questions on superannuation, I'm happy for you to reach out. Some of them I may be able to answer, and some I'll direct you to our wealth management team. So that's the conclusion of the formal part of the presentation. And I might just give you the answer to our second poll question. Would your executor or your family know where to find a copy of your will? 60% of you said yes, and 27% said no, and sorry, I should say 40% said no. And some of you don't even know where your own will is, according to the poll. So that's a little bit concerning. So you do need to tell your executor and your family where they can find a copy of your will. And sometimes you do need to sit down and explain why you've made certain decisions in the will before you pass away, because it may be easier for your beneficiaries then. So I'd like to thank everyone. We've got a few questions that have come through, and some of them are for Jess. So I might just ask these questions for Jess. So Jess, what happens if you don't have a will?
Yeah, great question, Matt. And it is something that we do hear from time to time. The short answer is, if you don't have a will, it's not the end of the world, although that's contrary to what we're saying today. Ideally, you should have a will in place, but if you don't, the Administration and Probate Act in Victoria, or the Succession Act if you're dealing with New South Wales assets, will set out a legislative hierarchy of who should receive your estate. Now, that might not be who you would like to have receive your estate, but the default order in the legislation is, if you only have children with one partner, everything would go to your partner in the first instance, or if your partner had passed away, then to your children. If you didn't have any children, then your parents. If you didn't have any parents, then your siblings. So a lot of our clients who come and see us and are working through those issues in their will often end up doing something far different to what the legislation would dictate should happen if they had passed away without a will, which is why it's so important to make sure that you're choosing the right people to step into that role and to act as your executor and to be your beneficiaries, so that you're in control of who gets your estate, and it's not up to a piece of legislation that you've probably never come across to make that decision for you. So rest assured, we can still work through that situation with you if you or a loved one doesn't have a will and they have passed away. But it just makes things a little bit more stressful in some circumstances for our clients, particularly with the clarity around those initial couple of weeks where somebody's responsible for organising a funeral, for making decisions about burial or cremation and things like that. And that's where it's really important to know who your executor is and to have made that choice for yourself, so that you can give them that information about how you would like those sorts of things to be handled. So if you don't have a will, basically the legislation will dictate who gets everything and who's in charge for you.
Okay. Thanks, Jess. And I guess sort of going on from that, what would happen if you didn't have a power of attorney in place?
Yeah, again, great question, Matt. So often we do come across this situation where somebody needs to be appointed as someone's power of attorney, but the person that they'd like to make decisions for doesn't have what we call decision-making capacity, or doesn't have the ability to make their own decisions about who should make their financial and personal decisions in a power of attorney situation. So what needs to happen in that circumstance is, if someone doesn't have a power of attorney, but somebody else wants to make decisions for them, they need to apply to VCAT, which is the Victorian Civil and Administrative Tribunal, to be appointed as that person's decision maker, either for their guardianship type decisions, which would be a guardianship order, or for their financial and legal decisions, which would be an administration order. Now, I know that VCAT are doing their best to keep up with their current workload at the moment, but they do have a little bit of a backlog, which is why it's usually not the most efficient and time-sensitive way to appoint somebody as your decision maker in that situation. So that covers off on your enduring power of attorney in terms of making that application to VCAT. If you don't have a medical decision maker document in place, then the legislation in that situation actually sets out who would be your medical decision maker, and it would default to your spouse or your eldest child, then to your children in order of age, then again to your parents and to your children. But again, that might not match up with who you would want to be making those decisions for you. I know some of our clients tend to wince when we tell them that it might end up being their eldest child that they might not be on great terms with, who might end up making their medical decisions, or that it might be anybody who thinks they're appropriate to apply to VCAT to make their financial or personal decisions that could end up in charge of those very, very big, important decisions for them. So that's why it's so important that you do have a think about who you would want to make those decisions for you, and that you put the appropriate documentation in place to make sure that the people you trust are in charge of those decisions for you.
Thanks, Jess. I've got a question here from another Matthew. He's just going back to, and this is probably one for me to answer, going back to my example of the testamentary trust and the $1 million cash being invested there. and maybe the yield at 3% isn't good enough. So we're looking to invest in a share portfolio and/or property. So if the funds originally went into cash and were in the testamentary trust, and then you decided to change the class of assets within that testamentary trust, the incomes can still go to those minors, because those funds still ultimately came from the deceased estate. So the answer is yes, you can change the asset allocation within that testamentary trust. It's only if you're investing funds or injecting funds that didn't come from an estate into that testamentary trust that some of that income may then be tainted. We do have one final question, and Jess, for you, it's what should you do if you have overseas assets?
Okay, interesting one there. So your Australian will can only cover off on assets in Australia. So slightly different to powers of attorney, which are state by state based. So you do need a Victorian power of attorney for your Victorian assets, or a New South Wales one for New South Wales assets. You only need one will to cover off on all of your Australian assets, but that will can't deal with your international or overseas assets. So it's really important to make sure that you have a will in that jurisdiction that you own other assets in, so that that can deal with your overseas assets. And Matt, did you have an example of that you wanted to run through with us?
I certainly do. So a few years ago, we had a client and they had assets both here in Australia and in the UK. And the Australian will had the primary beneficiaries as the daughters from the first marriage. And it was signed on the 29th of March 2007. And then there was a UK will done after that, and to deal with the UK assets, and the primary beneficiary was the second wife. The Australian will, the wording was, I revoke all prior wills with the exception of any will relating to my property held by me in the United Kingdom. The UK will, what it said was, I revoke all prior testamentary writings. And because that was done after the Australian will, it actually revoked the Australian will. And so only the UK will was valid. And that's certainly not the outcome that the deceased person would have wanted, because potentially it meant everything, all his Australian assets would also go to his second wife rather than the daughters from his first marriage. So you do need to be aware that if you do have multiple wills in multiple jurisdictions, that they're not revoking and they work with each other. So I think that's a really important point to know. So I think that concludes today's presentation.